Here we got Robert Simon on. He's here to talk about how he tried a low-impact collision case and got a $15 million verdict. Robert, how you doing?
I'm doing well to quite well. How are you guys doing?
It's going, man. It's going. It's the end of the year. So while people like my fiance and others are like, oh, let's coast through like this December, we're freaking out, like trying to get everything done because insurance companies are trying to get things off the books. And you know how that is.
Settlement season, man. No better season than settlement season. Q4, baby.
Absolutely. And here we are scrambling, trying to get $15 million out of a low impact soft tissue injury. So this is perfect.
It was actually $16.5 million, and they ended up paying all of it. So
awesome.
What insurance company was it?
It was State Farm. State Farm was pretty. So there was that calendar year. I think I tried 4 cases against State Farm, all up and down California, all spine injury cases, all fusion cases, San Diego, Orange County, LA, and San Francisco, and all the verdicts were like. The lowest one was 3.8 million and the highest was 16.5. But yeah, man, like I just, I founded my firm in 2010, the justice team, with just me. Now we have 20 lawyers. I got like 50 staff, and started another company called Justice HQ, which we mentor a lot of lawyers, membership based, high level consumer lawyers to share information just like we're talking about now, and do office space solutions, case access, just kind of change the world. But I truly believe these cases are easy to win, but you have to have the right recipe. You have to really know your client. You got to sit down with them. And these cases just aren't about what the medical bills tell you or what the insurance adjuster tries to push on you. It's a different thing, man. So I'm happy to share that knowledge, man. And I can talk for days about that case.
Yeah, we really appreciate that. I definitely feel like you have that rising tide raises all ships type of mentality. And those are the people we love working with and talking to. And you hit on a great point there. I mean, the insurance company has a playbook. They have a way they tackle all these, the way they defend them. So going into it, like you said, when you have your game plan, when you have the way you're doing it set out, you're going to make a big impact. So yeah, we're real excited to hear about it.
Yeah. So, I think the first thing, in that case in particular, I got brought in probably halfway. Most of my business, I get brought in by other lawyers on bigger cases, usually spine or death cases. Sometimes early, but a lot of time it's in the middle of litigation. So before I decide to take any case, and I recommend every lawyer to do this, you got to review the entire file. We play a game here called Find the Grenade. There's got to be some reason that this case is not getting paid, or it might be too difficult. There's no perfect case. So what I did is I encourage everybody, sit down with the client, the potential client. You can do it on Zoom. I prefer to do it in their home. You get a feeling for them. And if you like this person and you are rooting for them and you believe them, well, the jury will too. That's an A1. So in this case where, there's a light to no impact. I mean, it's crazy. If you looked at the photographs of this car, and this guy had major injuries. He had 2 fusions at that point, a cervical and a lumbar fusion. So I met with him, single dad at his home, loved the guy. We hit it off. I was taking pictures of his medicine cabinet, all these snooping around his house and shit. That ended up being very powerful trial exhibits. After I did that, I said, I like this guy. And then you do a deep dive. For me, I review all the medical records myself, and I'm actually working with some AI now to be able to grab that data quicker so I can review these cases quicker, the critical items I'm looking for, MRI findings, nerve root issues, first complaints of what we call radiculopathy, pain down the legs, any prior injuries, any prior complaints. I'm trying to automate that to make the case review a lot easier, and I'm pretty close to doing it. But then I go medical records, like the client, check box. Review the medical records to see how can I deflate all of the defense. I know the defense playbook, right?
Yeah.
You're going to say just degenerative.
Yeah.
Just getting old.
Number one. Yeah. Number one. It could be 3 years old. Degenerative.
You got rear-ended, not enough force to cause a disc injury. I mean,
right.
Whatever. So I'm actually we were talking earlier, I'm in the editing process with the trial guys. We're going to finish up a book in Q1 about trying these exact spine cases. It'll be a playbook. It'll be from case intake to discovery to doing the client's deposition to the expert depots, and you're winning the case before you get to trial. I'm trying to call the book Small Disc Energy, but I don't think they're going to go for it. We'll see. But yeah, not enough force to cause impact. It's just degenerative. Right. And of course, the other ones, medical bills are too high. Your client's a liar, cheap fraud, no acute sign of injury on the MRI film. I mean, I always just go down a checklist. You know what they're going to say and defeat it all the way through discovery and expert depositions. I like to just straight up ask they always hire a doctor. Doctor, you see patients, right? Yeah, I see patients. You got hired by the defense. Yeah. Do you treat patients that were rear-ended in car crashes? Yes. And you've had patients that got rear-ended in car crashes that have had disc injuries, right? Oh, absolutely, I have. And you've done surgery on them. Oh, yes. And these are not even big impacts. No, they're not big impacts. So, doctor, you'd agree that people can get disc injuries in low-speed car crashes? Well, yeah. People can herniate a disc. Well, yeah, from sneezing, of course. Then they hire a biomechanical expert that says it's impossible. And it's like, come on, man.
Yeah.
Give me a break.
Yeah, that's a great line of...
Yeah, don't walk away from it. Like, I teach a lot of jury trial stuff to lawyers, and it's like, same thing. Don't run for your bad facts, man. Get up picking a jury. You're ask your worst facts to them. You're doing a focus group to get the bad juries off. So don't run from your bad facts. Embrace it and push it all the way through.
I love that line. I love that line of questioning, because even if you get the opposite answers, that's good for you too.
Exactly.
Could you get injured from a low impact? No way. What are you talking about? That's ridiculous.
Yeah, you've investigated thousands of these cases, all hired by the defense, right? All of them. Every single one of these cases, somebody said they had a disc injury. Their doctor said they had a disc injury from it, and these people needed medical care from a rear-end car crash. They're like, yes. And every single time you said, not true, right? Yeah, and they pay you millions of dollars for that opinion. They sure do. Well, let's take a look at your studies you're relying on. And all these studies are like 2 participants, and they're usually working for an insurance company, doing it in an insurance company lot. Like, I do a deep dive into their studies, and it's like, come on, what's your sample size? Is it these 2 people in the study that are participants in the study, that are authors in the study, or these thousands of people that you've been investigating over the years? And by the way, who's buttering your bread? All right, thanks for playing, right? So, but it's a big thing because people run away from, they have bought into the defense industry mantra, and they're very good at messaging. Low impact crashes, fraud, right? That you can't get hurt from them. Yeah. Fender bender, right? This is the mantra they put out there. Just don't buy into it. Create your own.
I feel like, at least lately in my depositions, I want the defendant doctor expert, because no matter what, if I have some sort of villain, and he's always going to be a villain, he's going to stick to really bad opinions, and he's going to hold them all the way through. And that's when a jury really loses it. They may not lose it on the defendant's client, right, or the counsel's client, because, reality, you can always say people make mistakes, blah, blah, blah. They come off well, blah, blah, blah. But if you have that expert and you really make him look terrible, the jury's going to really start looking at your client saying, like, we want to help this guy, because the other guy, he's a terrible human being.
Yes. And that's what I say. Like, that's why you have to love your client, right? Because they have to root for them. And I remember I wrote one article for a periodical, this was years ago, but it's called Finding Your Villain. It's exactly what you're talking about. And you have to channel the jury's emotion and anger at someone. And it better not be you, your client, or them, you asking for money. So usually it is the defense doctor. If you have a very likable defense lawyer, a likable defendant, the jury's just going to try to find a way for them to win. They just will. But if they have a very, like you said, a person that's taking crazy positions on the defense side for an expert, that's your villain. Channel it through them, right? But that messaging is very important, because we're seeing now what they call nuclear verdicts. I think it's called nuclear negligence, to be honest. I mean, we're very, very, very high verdicts for our firm this year, and ever since the pandemic. And I think jurors are pissed off, man, and they see this fake junk science bullshit, the fake news, the fake data that these biomechanical experts are coming in and try to present to them. And then you pick it apart and you just say, look, you're just one of those headline doctors, right? The clickbait you see in social media. It's just, can't get injured in a rear-end car crash. And then we look at your actual data and the reason you came up with this opinion. You think the jurors aren't going to do their research, right? Yeah. You think they're just going to get a YouTube PhD and not pay attention? And jurors get pissed off.
Also, and pulling the jurors from all my trials, what I find interesting is that, here in Texas, we can't talk about insurance, and sure it's the same, in all your venues too. But, the jurors aren't stupid when you have somebody that is, middle-class worker, very average, doing well. But then there's 3 or 4 different experts, There's a team of lawyers on this. They know the insurance is fronting this bill, and then they're directing this defense. And they're way more intuitive than I in the beginning I gave them credit for. So, sometimes the more they throw at it as a defense, the more I feel good about it. You start to become that actual David and Goliath. What are these people doing just to avoid this responsibility?
And I think that's important because all their experts never agree with each other and they never talk to each other. And I like to create a chart and ask them the same question in expert depositions, and they never agree. Because the truth is easy. It's this confolded bullshit that people make up that they can't be consistent on. The same thing when I try a case in California, Arizona, or Texas, you can't say insurance. But you can tell the jury, it's one of the jury instructions, things you cannot consider. You cannot consider whether somebody has insurance. You cannot, if somebody in the back of the jury room says, hey, I'm worried that the defendant can't afford the verdict. You can't say that. You can't consider the wealth of the party, whether somebody has insurance, you cannot do it. I mean, the messaging, and same thing. When I put the defendant up there, I like to list all the experts' names and be like, do you know any of these people? And they're like, no. Did you know I usually add up on white papers that the trial goes on just on butcher paper, how much they're paying each expert. Say, come on, look how much they pay these people. This is insane. And I do a timeline of things important because you don't want the jury to think that you went and hired all these experts in these disciplines. You have to show the jury that they hired all these people when they hired them, and then your client to spend all this money to counter their BS just for a simple fact. I use Occam's razor all the time. The simplest explanation is almost always true. It's a theme of every one of my trials. And it's what's the simplest explanation? This person got in a car crash through no fault of their own, got injured, and had these medical bills and money's due. Or this is what you have to believe for the defense. And I go through a conspiracy theory slide. And when I do my PowerPoints, I drop in all this shit. The ER was in on it. The MRI was in on it. Every doctor was in on it. It's even some of the defense experts were in on it. There's this huge conspiracy. This is what you got to believe. There's a huge conspiracy. Mm-hmm. Or this person's hurt.
Yeah. We manufactured witnesses, and everyone's up here perjuring themselves. This is what's happening. So I know we kind of went off track, but So as you were talking about, you meet with the client, you like the client, you go through the meds. What's kind of next in your process of evaluating these cases?
It's the next step is usually I'll figure out. I can usually evaluate a case pretty much based on what the policy limits are, if it's open or not, where the jurisdiction is, who is the defense experts, who are the defense lawyers. That's critical in some of these, I can tell you how much money we'd probably have to spend on that case, depending on who the defense lawyer is, knowing who they usually have to hire. And then it's usually setting landmines because I know who they're going to hire, what they're going to say. And then you start defeating them in discovery if you can. You can have your client answer certain questions in the deposition. You can have written discovery answers that really crush them. One big thing lawyers lose sight of is these do not have to be absolutely acute injuries. They do not have to be acute disc herniations. These could be an aggravation of a pre-existing condition. Every jurisdiction allows it. Both roads lead to Rome. And I tell the jury the same thing. Doesn't matter if it's acute or acute on chronic, doesn't matter. They use this word called degeneration. And what does that mean? It means we're aging. And guess what? Every expert went up here and told you every single person after the age of 20 has degeneration in their spine. Degeneration. And every single person can be asymptomatic their entire life without an inciting incident. And every expert agreed, usually if they were with Rosado was asking the critical question, if this crash never occurred, if it never occurs, when does my client have pain? When do they need medical treatment? When do they need surgery to a reasonable degree of medical probability? They can't answer that question. What are they going to say? They're going to say, well, when they were 42, they would have lumbar spine pain going down their leg, need an epidural, and it had surgery. And I'd say, okay, well, you based it on they had no prior history, just because when they were 42, that's when they were going to get it. He says, yeah. And I'd be like, when's Madam Court Reporter going to need spine surgery? Jury usually laughs. Well, tell them. I'll tell you right now, I'm 42 years old, and I've never had a doctor seen for back pain before. So tell the jury, this is all the facts you need. When do I need spine surgery? Tell them. I'd say, who do you work for, Miss Cleo? Do you have a 1-900 number that we can call? But yeah, that's a critical question. Embrace aggravation of pre-existing condition. If you categorize the questions like you do in your venue's jury instructions and ask your expert and their treaters those questions, would you agree that my client had a pre-existing condition that made them more susceptible to injury? They'd say yes. You'd agree my client had degeneration of their spine? Yes. And you'd agree that the pain was caused by an aggravation of this pre-existing condition? They'll say yes. So that's bullshit when they say there's no structural damage on the MRI film. Yeah, that's usually true because MRIs are done more than 3 months usually after a car crash.
Right.
At that time, any edema, swelling, all that stuff is gone. And you'll get them to admit that if you ask the question correctly. So you would say if you look at the clinical picture, just the clinical picture of the patient, you'd agree that everything lines up. And they'd be like, well, yeah. So can you say anything to a reasonable degree of medical probability to what is causing the pain or has caused the pain of my client since this car crash? I can't tell you. Well, let me tell that. Okay. So these people paid you how much money for this case alone to figure out one thing, what's causing the pain? And you don't know. Okay. You don't know. And you don't know what's causing the pain. You don't know what started to cause the pain. And then they look all foolish, right? It's like, so it's either this car crash or you don't know.
Yeah.
All right.
Well, I think you brought up a good point that a lot of the experts fail to realize is that what you said, there's allegedly they're hired to figure out what it is, but really what they're really hired just to say it just wasn't this.
Yeah.
You know?
Right.
And that's not, they can't do that. And I think that's why a lot of these experts, like you just said, if you line them up, with some solid questions logically put forward, they can't weasel out of it. They can't lie. They can't, because they're not really there to find the truth. They're there to give the opinion that the defense wants them to.
That makes me feel better.
Yeah.
Okay, here's this client's medical records. Find any other reason besides this car crash.
Yep.
Yeah, and I mean, and as a form
to the standard, and I think that's important. I think most of these cases are won during expert discovery, because I think if you ask the questions and frame it the right way, and most of my depositions are very short. Like we live stream a lot of these to my firm because you can do them all virtually. We add a link, like my Justice HQ, the other company, people can just log in and watch me take these expert depositions, right? They're short and they're to the point. It's just, I usually come right out the gate and just ask them that critical question. The crash never happens, reasonable degree of medical probability, what treatment was unreasonable? What treatment should never have been done? Which treatment harmed the patient? And I go down the list, defeat all the defenses, get the concessions you're going to get. They're going to say what they're going to say. Right. Yeah. And then, the other gift is if they've seen the client, right? If they've seen the patient, was my client faking or exaggerating? Show me your report where it says that. And the other thing these whores, for lack of a better term, do is they give their opinion before seeing any medical records. So you can see when you get their file, when they got the MRI films and when they got their records, they'll see the patient and write a report and completely wash them out. And they'll base it on the MRI findings, all this other stuff. And then you pin them down like you never even had the MRIs when you washed them out. I mean, this is a joke.
Yeah.
Right? But they're just plug and play. They're just there to say what they're going to say. But I beat the shit out of these guys so many times. It's usually concession city. I had this one radiologist. He was here in Southern California, Stephen Rothman. He passed away last year. He would make $1.5 million a year doing defense work. He would gladly admit it. But he loved me because he loved the game. And if I asked him the correct question, he would smile and he would just sing like a canary. And I'd be like, well, Dr. Rothman, if somebody did have a disc herniation at this level and it was causing nerve irritation, where would it travel down their body? And he would tell me. And I'd say, okay, you'd agree this is unlikely to be an acute herniation. He's like, yes, I agree. I said, well, you'd agree that if you look at a clinical picture, that these symptoms were aggravated or caused by the car crash. He'd be like, yes, I agree with that. And then the defense attorney's like, what the hell is going on? I say, Dr. Rothman, you'd also agree that the biomechanical stuff, it's all a bunch of BS. Yes, I would agree with that. Explain. This is the defense expert. It was high hilarity, but people appreciate it. If you learn how to ask the questions the right way, in the book that we're doing, I'm actually doing actual questions and answers that I've done so many times. But don't be afraid to keep asking the question, because a lot of these experts they want to get squirrely, not answering. Just keep asking. Be bold. So I want to ask you again, yes or no, or answer this question, because they have to do it in front of a jury. So
yeah, that is a great point. And I can tell you as a former defense attorney, when that would happen in depositions, in the moment you're very upset. But later, and maybe this is just me, I can't speak for all of them, but I would be so happy, like, oh, this is great. I'm going to write this expert really just shat the bed. Let's play these policy limits and get out of this so I can go to my 200 other files. So, sometimes, like you said, they're happy to give you the right answer. Defense is happy to write it up the right way. And, if everyone's doing their job right, that's the time to settle.
Yeah, and that's a good point for the critical times when you can settle the case or get more value from them. as a defense lawyer, or during expert depositions, that's where the landscape can change. And why did this case go from you're saying valuing it at $100,000, $200,000 to you need to pay the policy of $1 million? What changed? Well, they took the deposition under oath of the defense expert. They got these concessions, different ballgame. Or when the client actually had the recommended surgery, redemand, changed the ballgame. Or took the deposition of the plaintiff. This is how well they did on XYZ. This is how they came out. Ballgame changed. So there's critical times, and you learn this through, other things, when to make demands, how to make them, the critical times to do it. And those are that expert discovery just absolutely changes the game. Able to resolve most of our cases if they're going to do it, expert discovery.
Yeah. You know what I'm really curious about? We talked about what your evaluation and taking case, but I'd love to hear what types of things come up that you say, hey, this we can't take this case, or we got to pull out, or what are your red flags? What are your big things that say, hey, this is just too much? Because we're in this conversation and I'm soaking up all this knowledge. I'm getting excited, like, well, I want to go try a case right now. I want to try every case, but you just can't. And I think your case selection that you take to trial, the cases that you focus your time, energy, and effort on are very, very critical. Yeah. So, what are the things that as much as maybe you love the client or something, whatever it is that you say, no, we can't, we got to focus on these are things that make us parachute out.
Yeah, I think the number one thing is, if the deposition was taken or if discovery was already answered by the plaintiff, did they lie? That's the one thing you can't get around. And this is the problem with a lot of lawyers that think that they, again, have to have the perfect case. If there's priors, they have to not embrace them or talk about them. They don't want to bring it up or lie about it. Don't do that. It actually makes it an easier case if they had a prior condition that was aggravated and you can prove it. Because then you just talk to the treaters that treated them before and be like, did they need surgery then? No. So then, the catalyst was the car crash that caused them to need it. It actually makes it easier. It nullifies all the biomechanical stuff and makes it easier. So if you go to the deposition, do you ever have prior pain? No. It's fuck, you have these prior medical records. They did. Case killer. Sorry. The other big red flags are, meeting the client and doing research. Did they lie about making any other claims? How much money and loans have they taken out? That's always a fucking killer, man. It's like, sometimes they need it, but it's like, what the hell? They're asking for money out of Jump Street, And the other one is, I don't care too much about big gaps in treatment. I've had cases where they treat for 3 months, take off a year, get a surgery recommendation, take off another year, get the surgery, and still get a big verdict because the science is still there. The MRIs were still done early on. But if there's no treatment, like in the first month or two, at the least, where they're complaining about the injury where they had surgery, it's very difficult to make that correlation unless something was going on. I think those are the biggest killers. We have like 30 critical questions at our firm. Again, we're automating with AI to answer those questions, but some of those are on there. One, people always forget about how much money did you take out, or what are the client expectations? Like if you talk to somebody, and it's like,
they really go on.
Yeah, I want $5 million in my pocket. It's like, well, first of all, your case, I can't even ask for $5 million on a case like this. Second of all, the policy limits are like $1 million. So best case, I get them to pay that. If your client's forcing you to trial and they're unreasonable and you're going to be unhappy working for them, like, go talk to a buddy lawyer of yours that you want to play a prank on, I guess.
That's great. Those are all. I think those are some of the things early on that we really didn't consider here at the firm. Being a younger firm, 5.5 years, in the beginning, you're just taking work as it comes in. And over the years, I think that's what we've really, really focused on is the quality of client versus the quality of the case. Because if you have a quality client, the case is going to be quality. But the converse is not always true. You might have a great case, terrible client. It could all spiral quickly.
And those are the tough ones.
Right?
Right?
So another one of these spine injury cases, again, you're dealing with the degeneration argument all the time. Is if you have a client that is severely obese or overweight, juries just do not like it. I'm sorry, just that's the way that it is. And they look at it and say, well, degeneration is due to you being overweight. And then the reason you didn't get better is because you didn't condition yourself and blah, 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 blah. It's hard to fight. It's an uphill battle. And it's hard to fight uphill against it. So
what is the mentality or what is the focus that you have when you're attacking one of these, low impact, missed, The pictures just don't show a lot of damage. Is it just a focus away from the pictures and what actually happened? Where's your head at to get the jurors out of? Because as a defense attorney, you think, I'm going to show these photos and then game over, right?
Yeah, I have these photos up the entire time in the background.
This again, embrace your bad facts, make your bad fact your best fact. I always talk about that. So first thing is I have the blow ups of the actual car, right? And in jury, so we're talking, first of all, you get these concessions from the doctors, the treaters that treated them. I never have the treater and the retained expert as the same person because I like to not taint the treater by want to have the patient advocate and have a different expert as retained. Then you can get two bites at the apple, two people saying the same things. And from the treater, you can get in all the stuff, low impact and still cause injury, blah, blah, blah. You can do the same with any treater, radiologist, pain management. All the people can be speaking the same mantra. Then you embrace it, right? And make it the whole defense industry slogans, blah, 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 blah. But whenever the one that I had for the $16.5 million verdict is I went up there in jury selection. I said, hey, do you believe in science? And I asked a lot of jurors this question, like, can you follow the science of it? Because the science was so strong. Like this guy, like in his neck had an extrusion, right? He had no priors. This guy had radicular pain that matched perfectly, like the day after the crash, all the way till he got the MRI 2 months later. It was like the exact same dermatome or nerve pathway. You should always have a dermatome map that you should be talking to your clients with. You should be taking depositions with. You should match it with the MRI to see if the clinical symptoms match. And I ask them all the time, like, once you get to that point, that science matches. So they just happen to have the same nerve injury down the same nerve pattern, match up with the MRI. That then they fix in surgery. They found the same condition in surgery. They alleviate it and that nerve pain goes away. Gee, what could it have been? But they're going to detract you from that with car can't get hurt, person can't get hurt. And I got a lot of jurors off on that for cause in that case. And I just said, who here says if there's not a lot of damage to the car, there's no way that you can be given millions of dollars? I need to hear nothing more. Car not hurt, person can't be hurt. Show your hands. People raise their hands. And I went through them. And the judge got them all off for cause. She was a great judge. And then what I did in opening, I said, look, I went through the science. And what they're going to do, instead of going through that science with you and concentrate on the actual harms and losses of this individual, and I already told you I'm asking for $15 million straight up. When I close this case, $15 million for general damages plus his medical expenses. Instead of going through the science with you, they're going to just hold up photographs of the property damage and be like, he can't get hurt. They're going to talk in colloquy, not in actual science. What's the first thing the defense lawyer did? He went over and got his blow-ups and held them up in front of the jury. And I remember the jury looked at me and they were just like, oh my God. I was like, it was kind of like, I told you guys this is what it's going to be. Right. And then their stupid biomechanical expert went up there, they moved way through trial, and he wanted to show these like dummy sleds of some of these crashes that looked a lot more severe than he thought they did. But it said right behind it, Insurance Institute of America.
Oh,
right?
no.
I can't play.
Oh, no.
I was like, who funded this? Right. And then
someone needs to refund.
One of their experts was this medical doctor, and man, it was one of my best crosses ever. But halfway through my cross, one of the jurors raised their hand. He was getting eviscerated. The jurors were holding their notebook like this so they couldn't see the doctor and looking at me because they didn't even want to look at him. One of the jurors raised his hand and said, hey, can we just deliberate right now? I think we get it. And I looked at the defense lawyer, and he was still like, offer $650K. I was like, geez, all right. It was his marching orders. He's a nice guy. He's a very good Boda lawyer. And it was just, I don't know. I had the nicest client in the world. We told his story. I think I've had three 8-figure verdicts on spine fusion cases, not paraplegic, not quadriplegic. I'm talking just cervical fusions or lumbar fusions and people that had chronic pain, and you're able to story tell after that. But you got to cut this bullshit out. You got to cut the legs out of the defense. You have to know how to depose their experts and get the concessions. Like I have a trial coming up on one where defense, you know what they're going to say. Look at their mediation brief. They're going to say, here's all our fucking arguments. And I go and just beat them with their own experts. Hey, are you of the opinion that my client got hurt because he's a laborer? They're like, no. Or are you saying that my client got injured by the chiropractor? No, I wouldn't say that because it's just shit the defense lawyer's been saying. So you take away all their defenses, and I'm going to play in just the deposition concession clips of their expert. So this case went being from disputed everything to this guy just gave up aggravation of everything. It's like the defense lawyer just thinks you're going acute injury. You start going aggravation. I was like, so you'd agree? He's like, oh yeah, it aggravated it, and yeah, the treatment was reasonable and necessary. I was like, so you at worst you think that the treatment was accelerated by 20 years at worst? Like, yeah, I'd agree with that. Thanks for playing. You just set a very high floor for my trial, But yeah.
Yeah, that's great. I mean, and I guess if you could just, if you were to have a young lawyer come to you, maybe they've tried a few cases that they want to get better. They want to start to aspire to the knowledge and expertise, and so that you have. What would be your playbook for them, or would you say, hey, these are the critical resources? I'd start here, 1, 2, 3, even if they're your own. Say, hey, start here, and then this is going to start to get you more dangerous and get you more confident in doing the types of things that you're talking about right now.
Well, number one is probably buy his book. Right?
Buy his book, buy your book. Yeah, we'll have that link.
And I do think it's such a low cost thing, but information is free. And like I had people reach out to me today, like one guy from Virginia is trying like a cervical fusion case. I'm going to help him later today, and I was like, just send me the medical records and the file. I'll take a quick look at it, and I could look pretty quickly and give you some pointers. But I think being in the room with other people that are experienced in it, and then like we have chat rooms at Justice HQ for even different channels of different things, right? And people are constantly helping. You can say, I want to collaborate on my case. Let me submit all the information for my case. You have, big hitter trial lawyers to people that are just starting, that are in this expert network of lawyers that are helping people. You have to have that collaborative event. These experts have been deposed before. People have the dirt on them everywhere. You have to find that person who has it and get it quickly. I think the best place to start, and it's hard because for you to get very good at trial practice, it's the lead up that's the most important. That's where you win or lose the case. But at trial practice, you have to be there, live it, breathe it. You have to see it. And so the practitioners is how I started, and most lawyers are, they want to get in the courtroom. You don't have the fucking time to go to the court or to be involved with these trials. The cool thing is now there's a lot of tools where you can be live streaming video depositions or watch video depositions or have a breakdown with a lawyer that took it afterwards to show this is why I asked these questions. These are the concessions I was trying to get. And you can also, with like CVN, I had a trial televised earlier this year. We got a big verdict on, and you can watch it soup to nuts on CVN. You have a subscription. We're working on like live streaming them at our Justice HQ locations where people can be a trial junkie and just watch trials as they're going. And then we have messaging where people can talk about why they're doing X, Y, Z. But you have to live it, breathe it. I think it's good for them to read trial transcripts as well. So I always tell people, email. I had the transcripts of all of that case from jury selection all the way through, and you could see the themes that I'm setting with the car can't get hurt, person can't get hurt. The science. Are you a good BS detector? Can you tell if an expert's just being paid to give an opinion? Like I set these themes in jury selection, right? About getting people off for cause and making sure that they could give money to victims. But being in the room, collaborative event, reading transcripts of what you are, and then figuring out, look, you got to defeat your audience is going to be anywhere from 6 to 12 people, depending on your venue. You got to speak to them. You got to do it quickly, and you have to do it efficiently and know what kind of language that they want to talk. So just talk to people that have been there before.
That's great advice. That's awesome. Yeah.
You guys fired up or what? I'm fired up now. Fuck.
Yeah, I know.
Yeah, I'm thinking about like what cases I go back and start working on.
Yeah, no, that's the problem with all these podcasts. We do this, and I go back. I'm like, we're trying every case. I don't care. Let's settle on nothing. See how
what's the first thing you need? Great client. Yeah. Great client, great store. You find that, and they're undervaluing the case, you're gonna do well on that one. I mean, but you go back, like some people miss things. Like sometimes it's not a disc injury that's causing the pain. People are like, why? Like this MRI doesn't have a big. By the way, size doesn't matter. It's how it affects the nerve. But there's no like stenosis. There's no nerve compression. Why is my client having all this pain? Sometimes it's not the disc injury. Sometimes it's like something else. A joint could be a facet joint. It could be an SI joint. Right. It could be some other condition. But it's you, the lawyer, and your case manager, who I always think should have medical care knowledge, helping guide them to the right professional to try to figure out their pain. Because sometimes it's not the disc injury. It's you as a lawyer has got to play detective a little bit here to try to help them. But I believe these cases are chronic pain cases and lifetime pain and suffering and limitation cases. Because I think everybody knows if you have a neck or back injury, especially one that has had surgery on it, it's not a cure. It's just not a cure. No. Like my brother's had my twin brother had a multi-level. He had scoliosis, like a spine fusion, a long one, and he's in pain every day, right? And he masks it and does what he can, but it's like you don't get the surgery, and it's like I'm cured, right? And most people know that. They get it. Jurors do.
100%. Yeah. Yeah. And also too, I'm sure that I've noticed too on some of our cases, relying on our experts, relying on not only, you know, learning the new science, learning, all you can about what is actually going on in the case. Like you said, I find that fascinating that you're using AI to speed up some of that process, because as plaintiff attorneys, our whole goal is to be as efficient as possible. We're not billing hours. We're trying to get to the root of it. So, we were just talking about this earlier that, as much as research we can do on our own, let's lean on the people that we're paying to give us that information too. Us experts, consulting with them before to educate us so we can speak in depositions, in trial, so that we actually know what we're talking about.
Yeah, there was a case that we were talking about earlier that I was like, dude, I actually don't know what to ask, and you're like, well, the expert does.
Yeah, just call the expert. He'll
tell you everything. He'll
tell you the questions.
I should do that.
What I think, like a lot of the spy knowledge I have is from defending when I was a young lawyer, defending a lot of expert depots, neurosurgeon depots, and just listening and being curious afterwards and asking questions, watching YouTube videos on these types of things and being educated in it. A great one is go to medical conferences. You can go as an attendee and just listen to some of this stuff. You can also pocket cam them. If it's a defense expert, you like to go as an investigator and get some good. We got one guy, like a radiologist, that we impeached the crap out of, where somebody pocket cammed him. He was speaking to a group of lawyers up in Oregon, and he was like, I can make any case a 7-figure case if I wanted to, if I were unethical. He's like, if you give me the MRI films, it's an art and a science, and I can get up there and I can just do my art. Oh my God. Like I got that video, certified transcript, and every time he was on the defense, oh boy, the judge will let you do it. Could you just ask the first question, doctor, isn't it true you can make any case a 7-figure case if you wanted to? What's he going to say? Yes or no? Like, he knows you got it at that point.
Unbelievable.
He's just leaving the stand at that one.
That's awesome.
Yeah. Well, I've had investigators follow some, there's experts. Some of them are reasonable. I think most are reasonable if you had not asked the questions, but some people are just such filthy liars. I'm like, well, if you're going to play that game, or you're getting tailed, I'm going to tail you for a couple weeks.
Wow. Well, I mean, obviously the magnitude of the cases that you're working on definitely,
they warrant it.
Yeah,
100%.
Well,
and not only that
case, and even if it's a lower level case, just remember you're going to see that expert over and over. So
that's true.
It's like we got one here, the guy's popping up here in Los Angeles County, and like I did a deep dive and found some really bad stuff about this guy. You hire an investigator to find things, and it's if you want to play this game, because the treating doctors are calling like, this guy's they're going to report him to the medical board. He's washing people out so hard and just saying things that are just not medically accurate, and it's egregious. And just remember, most venues, if they're hiring a defense expert that works at a university hospital, a public hospital, it's public records, and you can actually go and request what their earnings are and their declarations they provide to the hospital, because most hospitals require them to show how much outside expert work they're doing, because they can't be outside the hospital for so long because they're supposed to be there because they're a public employee. And these fuckers lie all the time. Oh, I do $5,000 worth of expert work per year. I only are outside of the office doing other things like 10 hours. It's like, these guys are making $500,000 a year doing this stuff. You can, and they're signing these things. I got one guy caught him hard doing that stuff. But you got to love this stuff, dive, man. But whatever.
Yeah, that's a wild experience out there. That's definitely outside the box thinking, and I think that's definitely comes from your passion. There's a lot of trial attorneys out there, a lot of people I know that I feel like are just going through the motions, but the good news is I feel like because it is getting harder to try cases, it's getting harder to get to trial. You're starting to see the people that are doing it really want to do it the way that you do, the same way you speak about this, the same way that you're all in, because at this point you have to be. You can't be, especially with your limited opportunity with how busy the courts are. So, and just like everyone says, when you're in trial, you're losing money, during that time where you're just pouring all this energy and resources. So if you're going to do it, I feel like we're shifting the needle more towards people that really, really want to do it and do it right. Which is why we really appreciate you coming on here and sharing this knowledge.
Well, the other good thing is, I think lawyers can do this now, is with, you can fee split with other lawyers, right? So when I first started trying cases, I was bringing in big hitters where I wanted to learn on their dime, because they front all the costs too, how to try these cases. And now it's even easier to do those things where you have what I call contract killers, solo trial lawyers that'll come in for a lower percentage that'll help you try that case. Because sometimes as a young lawyer, you just feel that sense of insecurity. If I don't know what I'm doing, or what if the judge thinks I'm too young and experienced for this. But if you have somebody that's been there before, and you're fee sharing on a lower scale with them to at least give you that credibility factor, or help give you the confidence with certain things. Because the hardest thing to learn in trial is usually jury selection is very difficult if you haven't done a lot of it. The law and motion stuff at the beginning is same thing, and you can contract that out as well. But jury selection, and usually like the plaintiffs, the cross the defense and the plaintiffs direct, are difficult to do. The other things you could do directs of experts, the opening, closing, or rebuttal is probably the easiest part of trial, believe it or not, because it's most scripted and you're not being challenged constantly. But do that. I mean, that resource is out there for you. There's no reason for you not to embrace it. And there's a lot of lawyers that are just waiting to be contract killers for you.
Yeah, I also feel like that learning experience just from that by itself is worth more than whatever you're going to get at that trial. Unless it's a multi-million trial.
It's true. So, and it helps your client out too. I mean, if you're splitting up the pie more, I mean, I remember the first fusion case I tried, not by myself, was with Brian Panish, and we ended up getting like a $9.5 million verdict on one spine fusion on a lumber that fell off a ladder. And, the amount of, it was a $1 million open policy. We opened it, they ended up paying it, and after the verdict. But the thing was that, like, how much more money did that client make with that decision to bring in Brian to try that case with me? How much did I learn on that? And how much more money did everybody make, including myself, by making that decision and splitting that pie 50-50, right? And, since then, I probably tried 40 spine fusion cases, by myself or with somebody else at my firm. And the recipe's there. It's easy to be done, but you have to see it. You have to be in the room. You have to live and breathe it. And I think, as we talked about this before, it's much easier to do those things now than it was 5 years ago, even, because the pandemic pushed us forward with this, and it's easier to do those things. So these lawyers, you got to embrace it, understand the technology, know what platforms you can go see this stuff on, how you can collaborate with people easy, and do it.
Yeah. I forgot who asked me the other day. They're like, well, you went to law school, so like, your learning is kind of like done. Now you're just kind of like practicing it. And I'm like, honestly, I learn way more every single day now than I ever learned in law school. Like, I mean, it's like exponential just per day. It's ridiculous. And it's because of what you said. There's so many, Trial Guides has a bunch of books, and I think I'm at this point like a platinum member. I go on all the listservs. I read stuff. I'm like constantly read stuff. I'm sending you stuff at like 2:00 in the morning. And it's because, well, one, you've got to love it, right? But two, you've got to like refine and build your craft. And the only way to do that is to see how other people are doing it and see if it fits within how you are as a person, or see why it doesn't. Maybe you can take something from it. So it's huge. It's really big. But the number one that you said, trying a case with Brian Panish, that's definitely worth whatever verdict you get, no matter what it is in a fee split.
Yeah. I mean, that's what it's worth. I mean, find your specialist. Like, there's some lawyers that are very good at like traumatic brain injury cases. If you got one of those, that's the person you should lean on, right? Employment cases, sexual assault cases, find the best at it, and they're accessible. You can legit just slide into their DMs right now on Instagram if you wanted to, and start working with people. So, but just don't go alone. Ever since, my first year out of my own, I tried 3 cases just by myself, and it almost fucking killed me. I'm telling you, like, the amount of stress, because you got to go back and work at your shop, right? You got to work on the other cases. No way. So just do things in teams. I mean, even if you have to give away some smaller percentage for someone to be a second chair or third chair being your motion writer, it just makes it fun. At the very least, it makes it fun. You're not as stressed. You could do more things. But that's my philosophy.
And you're not embarrassed if you make a mistake, because you thoroughly thought out the mistake with a team of 2 other lawyers, right? And you're like, okay, well, we all made this mistake. It's fine. We'll move on.
At least my mistake was co-signed.
What we do, so you can get a real-time transcript of the trial, even remotely, even if they don't allow it to be televised, right? So we have our motion writer. Like, one of my lawyers, an 8 or 9 week trial liability only. They got a really good verdict last week. But we're on a messaging board with everybody that's on that team for that trial. We have a law and motion guy that's on there too, getting real-time transcripts. So they're getting hit with motions at the fucking end of the defense. Motions at the end of the day, real-time shit, and advice some of the other trial lawyers that are on that board, on that messaging board with them, giving them real-time stuff, what's going on. It's just powerful stuff, man.
Hey, that real time's no joke. The biggest panic I ever saw as a defense attorney is when we were taking depositions and they were getting demands out as the deposition closed with real-time quotes we panicked. It was DEFCON whatever. We did everything we could to pull out of that case because as a defense firm, there's a big case, offshore injury, a very big client that had a bunch of our work. And, to see something like that, it set the tone. We were panicked. It was bad. Yeah.
Yeah, man.
That would be freaking out.
Because you're doing motions to eliminate, so motions to exclude during expert discovery. Take an expert depo. Next hour, you're getting hit with quotes from that expert's deposition of a motion. Yeah? You got to play to win.
Giving me anxiety just thinking.
I know. I was like, man, if I was on the defense, I'd be like, oh,
that's fantastic.
I need to write this report as soon as possible. Please help! Exclamation mark.
We don't get paid per hour. We get paid per haps, and we're playing to win.
Yeah, that's
right.
Great.
Well, Robert, I appreciate you coming on. If any of our viewers want to get in contact with you, what's the best way to do that?
If you just go to Instagram and it's @PlanetFunBob, I'm pretty active on there. You can DM me there. You can go to robert@justiceteam.com. You can go to justiceteampodcast.com, all kind of different variables. I mean, Instagram is probably the best way because I respond to a lot of that stuff. But
so you want viewers to slide into the DM. That's what you're saying?
Right, that's what I'm saying. Yeah. Just be semi-appropriate, right? As you can tell, I don't have much of a filter. But yeah, look, I honestly believe, guys, we're here on this planet to do good for our clients, but we should be having fun while we're doing good for our clients.
Yeah.
And there's no better way to do it with your friends. Most of the lawyers on my firm were best friends. We hang out all the time together, and it should be that way. If you're slumming along, you're not happy in this industry where you're doing it wrong, make a life change.
Yeah, that's a great point. 100%. And this was awesome. I really appreciate your time, energy, and I mean, this was great. Like you said, I'm fired up to go start looking at the docket and seeing what we can do out here.
You just cost me a lot more work.
Yeah.
So
well, in Texas, as you can't. You almost have to waive a lot of these medical bills because how they can admit anything in. So whatever. Just different art.
I've come to the conclusion that I'm waiving most of our past meds on almost every case. I really mean that, and I guess I don't really want to say that out loud because there's probably defense attorneys listening, but realistically, that's what I'm doing because at this point, it's an anchor for me. I think I can try the case and get a better verdict without them, honestly.
Yeah, it just depends on the amount that's owed and what the arguments are from. I generally do agree. There's been cases. Just depends. Like on that big verdict that I had, the $16.5 million, we had a very large lost wage claim. 2 or 3 million, but it came with some baggage, just some evidence the defense could have got in. So we waived it during. I knew I was waived it during motions to eliminate, and the client was fighting me on it. I was like, trust me on this. You're still going to get it as a general damage. Just trust the process. And there's been cases where I waive all the medical bills and still get a big result. Did it on the case we had earlier this year too. They still had to pay $4.5 million on that case, and it was waived it. We didn't talk about medical bills. We didn't talk about lost wages. It was just pain and suffering, right?
Yeah.
But the jury, I think you're right. I think that's the way it's going to go. So it depends, but I lean that way.
That's awesome.
Yeah, I'm hearing a lot of attorneys do it, and I also think that you can get a future cost estimate. That's very helpful as well too. Depends, and then it just there's no anchor. I can't. It's stress enough. It's so much better. It's really going to come down to does the jury like your client? And if it's a yes, then it'll go with you, and that's so much easier than dealing with all this stuff.
Then you're not dealing with attorney-referred care, the letters of protection, because it doesn't matter anymore, right?
It doesn't matter at all.
That's where you have to don't waive it until you're getting right before trial after they went all in on it, and then you do a motion. If your honor was going to waive it, then it's not relevant at all.
Yeah. But that's what you were saying earlier is that attorneys that are going through the motions. Well, the motions are what we know have been accepted by insurance companies, so we're playing their game. But these ideas stuff that you talked about earlier with the creativity, huge difference. Yeah. They don't know what to do.
All right, guys. Well, appreciate you having me on. And hopefully we learned a little something, got fired up. So
yeah, absolutely.
I'm going back to teaching artificial intelligence for the next 2 hours. That's my task.
Okay, perfect.
Take care of yourself.
All right.